Nice. So hello to all, and here we go again. We have a second part of a panel discussion, AI, justice, and public policy. Sorry. And it's a part of the big project, John Monnet Center of Excellence, European Fundamental Values in Digital Era. So we are really grateful to European Union for the support of this project. And we're also grateful for Yaroslava Mudrago National Law University, who also support this project and organize the big forum. And we are part of this forum also. And I want to thank to all our speakers and people who are joining to participate in the discussion. So, sorry, is it something with sounds? Please make it, switch it off, please. Okay, and what was the idea of this discussion? The idea was to have a broad discussion around all these issues, some benefits and dangers AI has, some influence on principles, on values, on power, on justice system, and also we want to discuss, of course, some issues of AI responsibility, or maybe a responsibility of some people who involved in this development and introducing intermarket. But the most part of this discussion was held yesterday. I think we can start now because it seemed that all people who want to join in this morning's slot already here. After this, I transfer the moderator power to Natalia and she will introduce the next speaker.
Thank you so much, Julia. Thank you so much for this extended introducement of me. So now with very big pleasure, I will introduce the next speaker, Яна Tshaskovські. I hope I pronounce correctly.
You probably do a better job than I do.
Okay, thank you so much. So I met Professor Jan when I was hosted by Ольборзький University in Denmark this spring and this winter. And I have very warm memories about this period of my research activity. Thank you very much to your university. It was really a wonderful time. And Яна Tshaskovські is a law professor at Copenhagen Business School and in Ольборзький University as well. For more than 25 years, he has dealt with legal and regulatory aspects of information technology with particular focus on data protection law, consumer protection law, and fundamental rights. So his presentation will be on the topic AI, personal data, and human dignity. So the floor is yours. So welcome.
Thank you. So, do you see my my slides?
Yes.
Or
yes.
Not? Okay, cool. Because I don't see them for some reason. That's pretty weird. So all this technology, I'm just going to put them on another screen. Sorry about that. So I can see them myself. Thank you so much for this warm introduction, and Julia and Natalia for inviting me, and Anna, none the least, for a very interesting, thought-provoking presentation. So for a start, I'm not a fundamental rights lawyer. I wish I was, and sometimes I pretend to be, but I come from consumer protection law. And I think actually we have some insights from market law in general that can be used in this field. So that is what I will speak about. I wrote this book, Your Privacy is Important to Us, came out in 21 in December. And it's about data-driven business models. And basically, it's also about AI, because AI is an important part of data-driven business models. So I think AI is more an evolution than a revolution, but we can talk about that. But I think the development towards automation has been going on for about 60 years. So it's just an evolution, but we can, of course, discuss that if you like. So what is artificial intelligence? So as Natalia said, I've been dealing with this for a very long time. And when we started out with IT law, the main focus was on copyright, because what was being digitalized were protected works. And what I've come to learn now that I've dealt in with a lot with social media and mediation of information is that it's our time as human beings to be digitalized. So that is what's going on. And what is interesting with AI is that it draws on challenges relating to both data protection law and intellectual property rights. So it's old stuff. So what happens with artificial intelligence? Well, it creates new forms of information. So we can create new information, disinformation. We can use it for creating marketing. We can do it for a lot of things. And we can also use it for decisions, including, what we see, what we don't see, what we can get access to, what we can't get access to, or other important decisions. So it affects humans and our behavior, both as citizens, workers, and consumers. I will come back to that. So my primary focus has been on consumers. I've elevated that to citizens, but I will just briefly touch on the workers' aspects as well. So what I've said popularly is that if we consider AI, generative AI, ChatGPT and stuff to be the premiere of artificial intelligence, we can definitely see social media as a dress rehearsal because it's been going on for 10 years. And what is interesting with ChatGPT, for instance, is that now it's there for everyone to see how powerful AI is. And it's not necessarily more powerful than it was 8-10 years ago. We just couldn't see it, but we were just subject to it. So there's definitely a need for safeguard. Another thing I would like to say initially is that AI, like data, has no intrinsic value. So data has no value. You can't take a USB stick and pay with it. I mean, it's first when you start using the data or you start using the AI that it actually becomes relevant. So that is a focus we should have, not about the technology, not about the data, but what is it being used for, which is also reflected in the GDPR. Okay, so for my book, I made this distilled version of the GDPR, which serves several purposes. One is that I can present the GDPR in less than 3 minutes, which I will do in briefly, but we can actually expand this model to apply to AI as well. So at the core, we have the data controller that needs to comply with the legitimacy requirement. So you need to have a legitimate purpose. You need to have, you cannot use more data than you should, and so on. We also have a principle of transparency. I'll come back to what transparency is and some challenges because I've dealt a lot with that in my book. It's not as easy as it seems. And then the last part is security, because the biggest threat when you're processing personal data is for most companies that they're being hacked and the data being used for phishing and other things. All this we need to do in terms to be accountable towards authorities. Legitimacy and transparency are important for what we could call empowerment of data subjects. So it's important that data subjects are empowered, that I will come back to. All of this is encapsulated in an overarching principle of proportionality, which we know as lawyers, and it's relative to the impact on privacy. So the more impact there is on individuals' privacy, the higher the requirement for legitimacy, transparency, and security. Yeah, so that was probably 2 minutes of presenting the GDPR. So what I've done in my book is I've compared marketing law and data protection law. And what we can see in marketing law is that it regulates a market failure. So the starting point when it comes to marketing is that you can market your products as you see fit, as long as there is an absence of unfairness. Whereas if you go to data protection law, it's a fundamental right. So there the starting point is that you should not process personal data. And if you do, there's a positive requirement of fairness. And as lawyers, we can appreciate there's a huge difference between absence of unfairness and actual requirement of fairness. So if you compare these two areas, we see that empowerment, transparency, and proportionality are found in both aspects. In the GDPR, we also have additional requirements of legitimacy, accountability, and security. Okay, so zooming in on empowerment, which I think is interesting as coming from consumer protection and data protection for that matter. So what I've found that is if we should talk about meaningfully talk about empowerment, we need to have some sort of agency, we need to have transparency, we need to have the absence of manipulation. And when we look into agency, we have the right to self-determination, which we usually take for granted, especially when it comes to fundamental rights and marketing and so on. We are rational agents. But if you investigate into psychology, which I've done for many years also, we realize that the idea of the rational choice is somewhat challenged with what we could call bounded rationality and bounded willpower. So we get tired when we are making decisions. So we speak about ego depletion. So our mental capacity, our cognitive capacity depletes when we are making choices. So it's not like we can make all the choices in the world. And that also, of course, relates to transparency. We can't read all information. What is interesting when we talk about agency is we have the economists themselves who come up with the principle of rational apathy. So it's a rational strategy for consumers not to read information that you can't change. So we didn't decide to be on Instagram or Facebook or TikTok or where we are. That is decided by our friends. So we have already made the decision when we sign up. Why would we read all the small print? Because we can't change anything, can't do anything about it, and we have decided we want to be on board. Transparency, I will come back to. I'll just here initially saying that information and transparency is two different things, and I will, of course, elaborate on that. Then the last thing is absence of manipulation, because it doesn't make sense to say we are empowered if we are being manipulated. So both transparency and absence of manipulated is reflected in the GDPR. There's a requirement of an informed choice when you're making when you're consenting to something, and the consent must also be a genuine choice. So I borrowed this definition from Cass Sunstein, which some of you might know from books like Notch. And he's written an article where he used the definition that the absence of manipulation is if you sufficiently engage or appeal to the user's capacity for reflection and deliberation. And if you look out in the real world, we will actually see a lot of situations when it comes to consent, when it comes to providing information and so on, we are not sufficiently engaging our capacity for reflection, often on the contrary. We should also recognize that you can manipulate choice architecture, so through design. So there's a huge design agenda going on in data protection law, and we should apply that, of course, to GDPR. I'll come back to that. But just recognize that friction plays an important role. So if you get a pop-up saying, you know, you want to accept cookies or you want to manage preferences, we will definitely accept cookies because managed preferences involves much more friction. And everybody knows about this in the business, so they know how they can design our behavior to their profits and benefits. So what I've come to in the book is that I've identified information asymmetries, new information asymmetries. So the old 1970 Akerlof information asymmetry is basically that the seller knows much more about the product and himself than the consumer, and we usually can use information. So if I'm selling my used car, I have a positive obligation to say, well, it's been damaged, or, you know, there's certain things you can't see, but I have an obligation to tell you loyally what's wrong with the car. But what has happened with data-driven business models, we can see that we have a tier 2, which is behavioral sciences. So the knowledge you have about how people make decisions, that has been going on for 100 years. Exactly, because 100 years ago, the first book on scientific advertising came out. So tier 2 is about how people in general behave. So that includes persuasive technology. It includes AI, when you use AI to, you know, define what people should see, how they should see stuff. And tier 3 is when you process personal data, when you know that individuals are different and you can treat them as individual and create personalized realities, which is in itself is a challenge, because it means that in the real world, we actually, if you go to a store, which is also filled with design of how we will walk through the stuff, you know, where you place stuff on the shelves has a lot of impact on what we buy. But what we are creating now in tier 3 is we have personalized realities. That means that I might go into a shop and Natalia might go into a different shop, you know, entering the same shop, but seeing different things on the shelves. So we can create these personalized realities, which actually makes us very prone to being manipulated. Okay, so there's a lot of talk about leveling information asymmetry. As I said, information is a good way of leveling tier 1. When we talk about information, we should recognize that information is basically just the bits and pieces that you say. Communication is how you say it, and transparency is actually the goal. So I usually make the comparison with a window. A window is transparent and a wall is opaque. And what we want to do is going from the opaque wall to the transparent window. How do we get there? Well, we use information as a tool, as a means to get to the goal of transparency, which of course also includes the fact that you can't get 100% transparency, because that would require too much of the consumers, because you're putting a burden on the person who is reading all the information and needs to make sense of it. And it's actually quite difficult to do that. In addition, we have something called frames and storytelling, which is basically how you tell a compelling story. That's been used in politics for a long time. It's used in marketing. It's used everywhere. So one of the most wrong or scary frames I would imagine in storytelling is about paying with personal data, because we usually say, oh, we pay with personal data. And I will come back to why that is a problem. So solutions, where do we go? Well, the first of all, we need to understand the deal. So when it comes to data-driven business models, including the use of artificial intelligence, if we look into automated decision making that Anna also touched upon, we actually have an information requirement saying that you should inform the data subject about the significance and envisaged consequences. Use that as a gold standard. You know, it's not just about saying this is what we do and then you have to make sense of it yourself, but actually you have an obligation to say, you know, this is important to you because these are the possible consequences of that. And Neil Postman said a long time ago now, what we should know about technology is not how we use technology, but how technology uses us. And I think that is the important part. So the marketeers of these technologies will tell us all the benefits about the technologies, but they will not tell the price that we pay. So if you look into Robin Dunbar, for instance, you might have heard about the Dunbar number. What he did was he looked into primates like human beings and apes, or other apes, if you like, and looked at their brain sizes and compared with their group sizes, and it actually correlated. So the bigger brain a primate has, the larger their natural group size is. So the natural group size for human being is around 148. So with social media, for instance, we can have thousands of friends, so-called friends, right? So we use technology to augment our capabilities. But if we look into what are the consequences of that, well, first of all, you become dependent on the technology because you cannot manage all these friends without the technology. You also become addicted to it because that is how it's designed. And you might actually miss out on a lot of other things. So just a way of thinking about when we talk about technology, we should focus on both what are the benefits and what are the downsides of using this technology. So it's not to say that technology is bad, just like Kranzberg said in his first law on technology. You know, technology is neither good nor bad, nor is it neutral. So it's not being against technology like the Luddites, but more like being curious about what are the downsides. Do we understand what are the significance and envisaged consequences? So the other AI I just want to mention here, I didn't even invent that word, but I like it a lot. So artificial intimacy. So that is one thing you can do with AI. So like when you had my AI coming up in Snapchat, for instance, it was just pushed to young people, creating a system with artificial intimacy, trying to get as much data out of them, making them as manipulative as possible. That is pretty scary. So we need to understand the externalities. So externalities, for those who are not trained in economics, is basically if you have a factory and you produce something and you have a waste product, if you just throw the waste into the river, it's an externality. The company doesn't pay for it, but society pays for it. So externalities is when you're introducing technologies and others than the company actually pays for the damage that is being done. So basically what is happening is that the human experience is being hijacked. And it is being hijacked for commercial, political, and religious purposes. Normally we speak about commercial marketing, which is, you know, okay, I buy something I don't need, I do that all the time. But what if you vote for a president you didn't intend to vote for, or is not in your best interest? What if you happen to be part of a religious group because they made you believe that that is good for you? That is scary. So again, coming back to information and decision, including decisions about mediating information. So it has personal, social, and societal consequences. That's another model that, I mean, it's really not new, but a way to look at it. So on a personal level, you become dependent on these technologies. You get addicted to these technology. You lose out on a lot of experiences if you're too much on your technology that is built to capture your attention, which is part of the business model. It has social consequences. So if you're used to only see ourselves or each other through a screen, and we are not capable of actually being together with other humans, which we are going towards. We see it with children, and they have a safe space. Oh, this is a difficult discussion. I can go to my mobile phone and it's much easier. But that becomes a scary place if we have grown-ups that, you know, go away from conflict and look into social media, for instance, because it's more comforting. And if you're losing personal capacity, social capacity, it also has societal consequences. So we just need to look at Cambridge Analytica to know what it can mean to society, the way things are being framed. And we can see it, all the misinformation that is coming out of Russia, just to mention that. It has significant societal consequences, what is going on. So we should be curious about the market powers and democratic implication. It's going the wrong way. So instead maybe of looking too much into the details, which we should also do as lawyers, we should also get the big pictures and see what is going on here. There's some geopolitical interest, what's going on with China, what is going on with Taiwan, what is with Russia, what is with you in Ukraine. I'm with you, all that can be. There's a lot of things going on that we should be curious about. So the way that human beings are being looked at from these technology and from technology and from business models is that we just see humans as programmable objects. We can define how you should behave. It includes the situations where we get the means to become consumers. That is where we are working. Just look into an Amazon plant and read a little about what's going on there. That's inhumane what's going on, I would say. So we have the workers, how we get our money. We have the citizens, you know, being part of society, being able to vote, being an informed public and so on. And then we have when we are departing with our money as consumers. So this is something we should be interested about. So what should we do? We should have a legitimate requirement. So we should make sure when it comes to AI, for instance, that there's a requirement of legitimacy. So a business shouldn't do anything unless they know positively that we should be able to do that. We should make sure that, including aligning goals. So aligning goals with the users, aligning the goals of societies. We should be curious about that. That means that providers of AI should be curious on a much higher level than just seeking profits and just making sure they're trying to get consent. So transparency, we should ensure genuine and informed choices. So transparency and explainability. So I use explainability here in quotation mark because I use it in a different way that I invented myself. So the gold standard must be that somebody consenting to something should be able to explain what is going on. I know that's not explainable AI, but couldn't that be the gold standard? That if you have somebody signing up, they should actually be able to explain what's going on. They can't do that with third-party cookies. They can't do that with automated decision and so on. We should have absence of manipulation and coercion, as I've been discussing. We should apply fundamental rights to businesses. And there's done a lot of work on that, and there's still a lot to be done. There are some challenges in applying fundamental rights to businesses. But what is important is that the protection we initially thought about fundamental rights were about the state doing stuff to consumers, or not consumers, but citizens. And what we see now in real life is that businesses are the ones doing the things we wouldn't want states to do. So we need to elevate fundamental rights also to apply to businesses to a much higher degree. And you could argue that that should be a part of the risk-based compliance we do for AI. And then, of course, we should also look to ourselves and say that we should make a distinction between artificial intelligence, mimicking human intelligence, and comparing that to real wisdom. So I want to introduce real wisdom here, which is also important and something else you can't put into a computer. So taking my model I introduced before you, I would say what we should look at, and that is basically my working theme of what I'm doing right now, is human dignity by design and by default, inspired, of course, from Article 25 of the GDPR. But shouldn't we have human dignity into everything we do as a business, especially when it has both personal and societal consequences? So what I would emphasize in this model is the requirement of legitimacy. You shouldn't put a service, an AI service on the market if there's no legitimacy. And of course, we should also consider proportionality, looking into both the personal consequences, but also the societal consequences. So sometimes you can have a situation where you have implications for individuals that are not so problematic, as we did with social media, for example, where it has some problematics. But if you look on a higher level, you will actually see that the fact that you are treating people individually actually has a societal impact. So we also need to be curious about that. So in terms of human dignity, you know, some of the core elements are liberty, privacy, and equality, which we should have. And we actually have that recognized. And I have this quote, and you can think about if you've seen it before, you know, anybody seen that the processing of personal data should be designed to serve mankind. I don't know if anybody's seen it before, but you could think for yourself. It's actually recital 4 of the GDPR. So it's actually in the GDPR that we should design the processing of personal data to serve mankind. So there's both the design agenda. So it's not only what you do, but it's also how you design it. And then as a final remark, I would say there's been a lot of focus on diversity, and I'm definitely not against diversity. But what I've seen, what is going on, especially in the US, but also in Europe, is that we are seeing that people are not really speaking to each other. So I would encourage that whenever we say diversity, we should also add unity, because we can embrace diversity and still be united. So as somebody suggested, Americans should learn to say, those of us who voted for Trump. But the framing was, oh, those who voted for Trump, we are against you. No, we should have unity. Those of us who voted for Trump, I didn't do it, but you're still one of us, because we need to be united. And now more than, not more than ever, but more than in a very long time, it's important that we look for unity and not trying to split up society. Okay, so that was about what I had intended to say. Good. Everything's good.
Yes.
Yes, and we have some questions. Yes,
Yes.
I also have one, and I see Bogdan have one. So we will open the floor to the questions for 15 minutes now. Please, Bogdan.
Yeah.
Okay. So thank you, Jan, for a wonderful speech. It was very enlightening, and I'm eager to read the book. And I have a question. So you've mentioned a couple of times that humans are, as you've put it on a slide, are programmable. Or in other words, that our decisions can be manipulated through different marketing techniques or through social media feed, what we get there. So, and I'm interested in the following problem, because I come from tort law. And so there was one interesting case where on a TikTok platform, there was a blackout challenge, which is kind of a thing that you have to struggle yourself until you pass out. And so that challenge was through the algorithms by TikTok was promoted to children, to minors. And some of the minors ended up dying because of that. And their parents brought a lawsuit against the TikTok platform and blamed them for the deaths of their children. So here is my question. Can we hold platforms accountable for the decisions that people make under the influence of those platforms, under the influence of those algorithms or the social media feed they receive. So that's my basic question. Can we blame the platforms for the decisions made under the influence, under the impact of those platforms? Thank you.
Right. Well, the answer is quite easy. Of course, we can hold them accountable, but we have in the US Section 230, and we have in the EU, we have the old rules from the e-commerce directive coming into the DSA about exemption of liability. So they will rely on that. So one discussion we need to have is because the whole idea of the e-commerce directive and Section 230 is that the platforms are just intermediaries. They don't do anything. Where in fact, what they actually do is that they mediate the information, they decide what people are seeing. And they also have an incentive to design the platform for the most impact, so more sharing, which has damaging effects to society. So we need to find a new balance there. And I think what we should look at is, could they be liable for their design of the platform, not for the content, because that they exempt to a very large extent, they exempt from liability, but could they be held liable for the way they have designed their platform to spread that allow for spreading this kind of information to children? And on another account, so that was my point about real wisdom. So we have to take responsibility as users as well, because as Anna said, there's a lot of focus on regulating AI and so on. But if we don't understand what's going on, or we don't care about what's going on, and I think the latter is true when it comes to a lot of social media and stuff, we don't care. We know there's something rotten in the system, but we still use it. I mean, I wouldn't, if my children were on TikTok, I would tell them not to be there, and I would explain them why. But we have a challenge because not everybody has, more than 20 years of experience in dealing with this. So we have a problem that there will be a lot of people, there will be a huge group of society that will not understand the negative consequences, and it's still to be pleasurable. So they will just get pleasure, not happiness, because that's something different, but they will get pleasure from these systems. So we need to inform the public also, because we can't regulate this completely. And I think that is a huge mistake in the debate, is there's so much focus on regulating. You see all these non-lawyers coming out and say, oh, we need to have smart regulation. Well, I mean, we have certain challenges with regulation. I write about them in my book as well, because I don't believe that we can completely regulate these business models from these big actors that has so much power. And when they get a fine of €500 million, it's just, parking tickets. It's a license fee they're paying. So what should we do? I mean, we should do all the things we can do, including legislation, but we should also take responsibility back, even though it's not fair that we should be responsible for what they're doing. But we should, think about what products are we using, how are we using them, and especially, as Postman said, how are we being used by this technology, and how can it damage society? Because when we use the technologies, we become vulnerable to manipulation, which has societal consequences, especially when we're talking about political and religious manipulation. So that was extending a little bit further than your question. Thank you for it.
May I have one in line of this? Despite the dark picture Jan drew, I totally agree about informational asymmetry and creating own realities, addiction. I believe it's also asymmetry of power gained by companies, by technology owners here. But given that the manipulation of people's choices with the help of AI can be really successful, could it ruin its self-determination and therefore human dignity? Because we don't know who we are, what do we want to do anymore.
I see children to a larger extent putting down their smartphones to say, I don't want this. But it's still the majority that are on their smartphone. So if we look at how we use technology, even though there's been a lot of debates in media and elsewhere about the downsides of this, people still love it. And it's because it is designed, so we have the artificial intimacy. So the pleasure of posting on social media, for instance, getting the likes and all that, it is releasing dopamine in your brain. It's like the most basic addiction we are talking about. And, you know, you can say, just tell a drug addict, you know, oh, you should just stop quitting. Yeah, good luck, right? It's not how it works. And I think, and I'm not the first one to compare our technology use with drugs, tobacco, cocaine, and so on. It is similar. So we need to do something else. The problem is that we are so much in love with this, and the politicians are so much in love with this. So those who say we should regulate this, look at how much money they spend on these platforms on marketing themselves for political elections. So we have a really dire problem. And one last point you could also make in this is, so power asymmetry is important when we talk about workers' conditions and consumers' conditions. But what if we get into 30% unemployment in society? What will happen? Because what AI can do, as it is growing now, usually we use automation to automate blue-collar workers, manual labor, and so on. So what we are doing now is we are actually replacing creative stuff, thinking. So you can say the higher skilled individuals. What will happen if we actually get 30% of unemployment in society? Just look into what happened in Germany the last time they had 2 digits unemployment rates. And for those who can't figure it out, that was First World War.
Yes, thank you. Maybe we need to promote this analogy with drugs and perceive some technologies as drugs in society.
Yes. So maybe someone else has questions to our speaker. We first of all give the floor to our guests. But if you don't, then I have a question, not maybe so broad as the previous questions were, and it concerns to consumer protection law. I really liked a lot the description of these tiers of informational asymmetry, which you showed on your presentation. You know, previously I didn't think so much about these asymmetries, and that they can be divided in modern times into these different layers. So thank you so much for this presentation of these tiers. And in this context, I have a question. Do you think the efforts which have been put during latest decade, maybe in the European Union in particular, and maybe in Denmark as well, do you think these efforts, I mean regulatory efforts to fix these asymmetries, to do something with them, do you think these efforts were enough, or we should go further and continue dealing with them? And in which directions should we do this when we are talking about consumer protection?
So in the we call it the information paradigm in EU law. So the information paradigm is basically that you give more information and you expect the recipient to read and understand, which is BS, right? That's not how it works. So, but we still rely on it, and we see it also in the AI Act. You should explain what you're doing. You should, you know, create transparency and so on. I think we should move towards that, at least what I suggest in the book, moving from an information paradigm over the communication paradigm that we are kind of approaching towards a transparency paradigm. We still have people who say that, you know, here's all the information, we are transparent. Well, I mean, it's only transparent if the recipient really understands the consequences of the significance and the consequences, as you have in Article 22 of the GDPR. That's why I like that so much. Also because AI is about automated decision to a large extent. Yeah, so I think we are approaching the wrong way. We can't just, we have to recognize that there's a limit to what we can process. Our cognitive resources are limited. And what should we use them for? Should we use them for reading Facebook, Google's privacy terms, or should we use it to enjoy life being with real people out in real life? Because that is, I didn't come back to it as a paying with privacy or paying with personal data is a misleading framing, because what we are paying with is actually our attention and our agency, which is a scarce resource. So we end up living much more of our life in these situations. And is it transparent? Do we understand what's going on just because we got all the information? So one of the things you can do if you look at consent in the GDPR, for instance, there's a requirement of a genuine choice and informed choice. It doesn't say transparent choice, but we have the overarching idea in Article 5 of the GDPR is focusing on transparency. So is it possible to consent to something if you haven't created transparency? Is it sufficient that you just give information? And I would say, for instance, when it comes to third-party cookies, which is part of AI, data source for AI, when it comes to third-party cookies, I haven't come across anybody who can explain that in a meaningful way. What will happen with my data? What are the significance and intent or the likely consequences of my data being processed 15 years back and being used suddenly to make me change my mind on a politician or a product or whatever? So, I mean, we should reframe transparency and have it mean transparency and not just a lot of information. I don't know if that answered your question.
Yes, thank you so much.
And the logical consequence of that is, of course, that we need to prohibit a lot of things where you say you can't meaningfully make this transparent and therefore you shouldn't do it.
Thank you so much. Yeah, I totally agree with you. I also thought a lot of this, information obligations overwhelmingly in our legislation, in European legislation. So maybe this is not the only point, I should say, because personally, I'm not that person who likes reading all these policies, all these terms and conditions and so on and so forth. I like asking people orally, and make them answer my questions. But when you are dealing with computers and some cell phones, you are deprived of this opportunity. But that doesn't mean that everybody starts reading the information, even if this information clears up everything. So yeah, I'm totally in. I agree with you. So thank you so much.
We now have a break, and I suggest to return 5 minutes past 11 in Central European time. It would be 5 minutes past 12 in Ukrainian time.
Can I just say thank you for inviting me and wish you all the best for the conference?
Thank you so much. Thank you for your participation, for your wonderful speech. It was really very, very interesting and, enlarging our horizons. So yeah, a lot of issues which personally I have never thought about even. So it was really very interesting in terms of thinking about analyzing new issues. So thank you so much.
Okay, so we return to the second part of our panel discussion, AI, justice, and public power. And we have 2 more presentations in this part. I will ask my co-moderator, Natalia Filatova-Belouz, introduce our next speaker.
Thank you so much, Yulia. With a big pleasure, I will introduce my other boss. Yesterday, I introduced my boss, Professor Yulia Razmetaeva, and today I introduce my boss at my department at our university. She is, so first of all, her name, Tетяни Цувіної. She is the head of the Department of Civil Proceeding, Arbitration and Private International Law of our university, where I also work. And she is a director at the Center for Mediation and Alternative Dispute Resolution. She is a qualified lawyer specializing in civil procedure and ADR, a member of the working group of the Ministry of Justice on the preparation of the draft law on mediation, which was recently adopted in Ukraine, and proposals for the ratification of the UN Convention on International Settlement Agreements resulting from mediation. So her speech will be, and the presentation will be on the topic online courts, modern challenges and prospects in the light of the deployment of artificial intelligence. So dear Tatiana, the floor is yours. You're welcome.
Thank you, Natalia, for introducing me. And first of all, let me say that for me, it's a big pleasure and a big honor to be here today and have the opportunity to share my thoughts connected with the development of online courts and artificial intelligence in the sphere of civil proceedings. So I will start my presentation. Can you see it? Can you see the presentation?
Yes, we see everything. Thank you.
Okay. So when we are speaking about ODR, we should say that ODR is currently recognized as one of the main trends in the reforming both private and public dispute resolution systems. And today, informational and communication technologies have become so firmly established in our common life that they have become recognized as the new normal. In Ukrainian, it means that like нова нормальність або новий нормальний спосіб життя, скажімо так. The Parliamentary Assembly of the Council of Europe, in its resolution Access to Justice and the Internet, Opportunities and Challenges, notes that access to justice is a cornerstone of any democratic state based on the rule of law and prerequisite for the effective exercise of citizens' rights. At the same time, the use of information technologies can improve access to justice as they not only have the potential to simplify and speed up procedures, but also to increase the consistency and predictability of results and their flexibility. Nowadays, several terms are used in the foreign literature and in Ukrainian literature to refer to the use of informational technologies in the administration of justice. And such terms are cyber justice, electronic justice, digital justice, online dispute resolution, or ODR. However, the interpretation of these concepts is not established either at the level of international documents or national legislation, as well as in Ukrainian literature. Thus, in 2017, the Working Group on Cyber Justice and Artificial Intelligence in Judicial System, CPGGT Cyberjust, within the European Commission for Efficiency of Justice, conducted a study aimed at analyzing and providing recommendations on the use of IT in civil proceedings. In this study, the CPEJ used term cyber justice, justifying its choice by the desire to expand the range of issues arising from the possibilities of using IT technologies in justice, and emphasizing the deliberate rejection of the term e-justice, which involves the use of ICT and as a means of administering justice in the digital world. In this study, the concept of cyber justice is understood broadly. And we can distinguish four main aspects or four main issues of the use of informational and communicational technologies in justice area. They are accessibility of justice, communication between courts and professionals, court administration, and direct assistance in the work of judges and staffs of the court. So at the same time, the use of ICT to improve access to justice, according to this commission, covers both access to courts, like ordinary courts, and also access to online alternative dispute resolution, such as mediation, international commercial arbitration, etc. At the same time, in literature, we can say that terms cyber justice, e-justice, and digital justice are used as synonymic terms. And when we are talking about Ukrainian literature, we can say that the most common is the term e-justice. So that's why, to sum up, we can say that e-justice nowadays covers such issues as electronic filing of documents with the court, like e-filing, electronic systems for distributing cases among judges inside the court. Also, we have such systems in Ukrainian courts. Also, electronic case management system, so-called e-case management, including electronic notification of the parties, electronic document management, audio and video recording of hearings, and other things. So the fourth element is ODR systems. The online, we can say that nowadays online courts is the part of ODR systems. And the fifth aspect or issue is the usage of artificial intelligence in civil proceedings. So let's move on to online courts, because online courts as well as ODR is one of the main trends in civil procedure area nowadays. So the first attempts to introduce online courts we can see in such countries as Canada, China, United States, United Kingdom, and currently the literature suggests distinguishing between two generations of online courts. The first one connected with technologies which lead us to transit written communication to the electronic systems. And for example, we can see among the first generation online courts, Australian electronic courtroom, so-called e-courtroom, which were one of the first courts which use such electronic system and electronic case management systems. So the second generation is hybrid dispute resolution systems, and this online course connected with the transition to online via full cycle of the trial. And in particular, we can say that one of the first courts of this of the second generation was Civil Resolution Tribunal in British Columbia. And this Civil Resolution Tribunal is very interesting and contain like 4 steps. These 4 steps or 4 subsystems. Like the first one, this is provision of information of the merits and information on the dispute through the Solution Explorer information platform. The second step is online negotiations. The third one, online facilitation, and the fourth, court trial. Civil Resolution Tribunal integrated into Canadian judicial system, and this court started operating in July 2016. Its jurisdiction is mandatory for disputes over compensation for personal injury caused by road accidents, most small claims disputes with the claim value of up to 5,000 Canadian dollars, and disputes arising between co-owners of apartment buildings, like condominiums. I will go to the explanation how it proceeds. So the first stage is the possibility of using the Solution Explorer information platform, which is free for all users, and it provides a person with information on the specific of their disputes. At this stage, based on a questionnaire filled out by the person, the nature of the dispute is determined, and also useful information is provided for the person, for the claimant, like potential claimant. And different norms of legal acts, explanations of legal issues, and so on, can be seen by the by this potential claimant, by the user of this platform. If the person wishes to initiate proceedings on this platform after this introductory usage of the first stage, the second stage begins with the filling out online forms with the most important information about the disputes, the parties of the disputes, and the main evidence of the case, and so on. It's like filing a suit, formal filing a suit. After that, the claimant is the claim is sent to the defendant, and the parties are given the opportunity to use the online negotiation procedure. So this negotiation is aimed to resolve the disputes, aim to let the parties the opportunity to try to negotiate. And if the negotiations are unsuccessful, the third stage begins its facilitation, which involves the third neutral person, assistant, who try to assist and facilitate the negotiation process. Actually, this person can be like professional conciliator or professional mediator, and this facilitation process is confidential and takes place using various IT tools that provides both synchronous and asynchronous communication, and this phase has two main goals. The first one is to settle the dispute, and the second one, if the first goal fails, to prepare the parties for the trial in court. And according to statistical data of Civil Resolution Tribunal, over 70% of the disputes are resolved at this stage. If the parties manage to settle the dispute, the facilitator, at their request, may apply to a judge to make such a decision binding. If the dispute is not settled, the facilitator, as a neutral person, helps the parties prepare for this fourth stage. And during the court trial, communication takes place asynchronously through the use of online platform, email, and other online facilities. The judge reviews the parties' written arguments, examines the evidences, and makes a binding decision that can be enforced. If an oral hearing is required, and it can take place when there is the need to question witnesses, for example, it can be held via different platforms, or by video conference, or even by telephone. The proceedings in such a tribunal lasts approximately from 60 to 90 days, and the court costs are approximately $200 of Canadian dollars, which is not so big sum, comparing it to the ordinary court fees in Canadian courts. The judges in such tribunals are lawyers with experience in a particular category of disputes, and the decisions of such tribunal can be appealed, but the grounds of such appeal is usually limited. Similar projects as Civil Resolution Tribunal took place in other states. For example, in Australian states, including New South Wales and Victoria. Another interesting initiative in introduction ODR in the justice system was the idea of creating Her Majesty's online court in United Kingdom. And later this initiative was transformed by Lord Briggs, who is a judge of the Supreme Court of Great Britain, to the civil online solutions court, which jurisdiction should be for the claims with the value starting from the £10,000, and later it should be increased to 25,000. This court, the introduction of this court is in progress now. The dispute resolution procedure in this court should also consist of 3 stages, which are quite similar to the structure of Civil Resolution Tribunal in British Columbia. So the first stage, it's like the stage of exploration, during which the parties enter information about their disputes into the online system, on the basis of which they are provided with information on the nature of the disputes, the rights and obligations, the validity of the claims, and so on. The second stage, it's case management stage, and in these case management states, parties can use online ADR, conciliation, or mediation, because according to Anglo-American tradition, ADR and usage of ADR and ODR and online ADR in courts, it's a part of case management conducted by the judge. And the third step, it's like dispute resolution, similar to court trial and civil resolution tribunal. Also in the United States, we can see examples of such courts like online courts, for example, in Michigan, the court, such court was introduced for disputes arising from non-payment of traffic fines. In Ohio, tax disputes for small amounts. In New York, disputes on debt collection and disputes on non-payment of traffic fines as well. And the same, like the similar philosophy of the court introduction in Arkansas, Texas, Nevada, Georgia, and other states. So in our opinion, it's especially important to emphasize that today we can see the new model of modern online court like a place for dispute resolution, like complex dispute resolution. And this new philosophy and this new model of modern online court connected with the introduction of 3 main steps of this model, like dispute avoidance, which corresponds to the first informational stage when party have the possibility to go more deep in the dispute and to understand whether he or she have the right for the claim in this particular situation. And the second is dispute containment, which is focused on the second facilitative stage, during which the parties try to resolve the dispute through direct negotiation or using mediation or conciliation or other dispute resolution. And if it fails, then party and third neutral try to prepare a case for the dispute resolution. And the third one, dispute resolution. And what is more important, that now we have that in classical courts, in ordinary courts, we have the accent to the dispute resolution, like to the third stage. But now the new experience of these online courts of the second generation show up that we need to focus not only on the third stage and efficiency of the third stage, but also on the first and the second stage. And it can bring us more good results in civil proceedings than just focusing on dispute resolution. And also we can say that online alternative dispute resolution mechanisms begin to integrate into online platforms of formal justice, becoming a part of these platforms. And this is an indicator of the of so-called hybridization of formal and informal justice processes. And this indicates the creation of a new architecture on the civil dispute resolution system, which is based on several fundamental provisions. First, it is dominated by a consensual approach, which allows to settle a dispute at the earliest stage due to the fact that the negotiation, mediation, and conciliation procedures are built into the dispute resolution system of classical kind. Secondly, such a system is focused on the users of such online courts, of such platforms. Thirdly, the creation of online courts increases the efficiency of judicial proceedings and saves state resources by automatization process or by the automatization of the processes. And fourth, the use of such system is less costly for the parties due to lower court fees and the ability to represent their interests by themselves, which is also very important in terms of access to justice and international standards of fair trial. And as I said, we have also the third generation of online courts, and this third generation online court is now only developing, and these courts connected, and this third generation connected with the usage of artificial intelligence. And the question of how artificial intelligence can assist judges or even replace them with artificial intelligence in the process of making judicial decisions are very important nowadays. The first attempts to use artificial intelligence in the judiciary have already taken place. And for example, in Mexico, the Mexican expertise system is currently used to advise judges in determining the question of the plaintiff's rights to a pension, for example. And at the same time, one of the most questions discussed in this area is the possibility of using so-called predictive analytics in judicial area, which allows a machine to predict a possible court decision based on the data which it has. One of such experiments was the program developed by Aletras based on the idea of analyzing the European Court of Human Rights practice with the subsequent possibility of predicting the outcomes of new cases. And according to statistical data, 79% of predictability were gained in this system. This and other attempts to use the capabilities of artificial intelligence in the legal sphere have even led the emergence of the concept of artificial legal intelligence, which is understood as a system that has the ability to provide expert legal advice or make legal decisions in justice area. The algorithms of operation of the simplest such system is that it based on the available data on users raises questions about the dispute in order to determine its nature as accurately as possible. The program then applies the necessary law to the clarified circumstances of the case, which allows it to make conditional or final decisions. Such system can be constantly updated and reflect the latest changes, as machine learning allows them to be constantly improved with the help of the new data sets. At the same time, the necessary algorithms should be developed that would conduct comparative and predictive analysis along with the form of probability analysis to obtain results that would be useful and informative. As you can see, replacement of a judge with artificial intelligence could herald the emergence of third-generation online courts, where not only the case consideration process, but also the decision-making process is automated. And in this context, the question arises as to the role that a person of judge should play in such courts. Some researchers consider the possibility of appealing such a decision and its review by a judge to be a necessary component of any automated decision-making system. For example, in this regard, the European Ethical Charter on the use of artificial intelligence in the judicial system and the environment was adopted. And also by a European Commission for Efficiency of Justice. And the Commission notes that the process of making judgments using artificial intelligence in civil, commercial, and administrative disputes should improve the predictability of the application of law and the unity of judicial practice. But of course, we can see some concerns connected with the usage of artificial intelligence in the justice sector. That's why in this charter, 5 principles according to which artificial intelligence should be used in judicial proceedings were introduced. And these principles are principle of respect for fundamental rights, principle of non-discrimination, principle of quality and security, principle of transparency, impartiality, and fairness of the trial, and principle so-called under-user control. With regard to the last principle, user autonomy should be expanded, not limited by the use of artificial intelligence. Lawyers working in the justice system should be given the opportunity to review court decisions and data used to obtain the results at any time. And such data should not be mandatory and should be applied taking into account the specific circumstances of the case. User must be informed in plain and understandable manner and language whether the decisions were generated by artificial intelligence tools, whether these decisions are binding, or whether different options are available to use this or that kind of conducting the decision. I mean conducting decision by artificial intelligence or by the judge. So they users also should be clearly informed about any preliminary processing of the case by artificial intelligence before or during the trial, even when the judge uses supportive technologies, and users should have the opportunity to object of having their case examined by a court in accordance with the meaning of Article 6 with the use of artificial intelligence. In our opinion, supporters of the possibility of replacing judges with artificial intelligence often do not take into account the role played by judges in society outside the dispute resolution, which includes important and often unexplored issues relating to the observance and development of the rule of law. First of all, there is a question of the legitimacy of decisions, of judgments made by artificial intelligence. In an ordinary court, a decision is made by a judge, and the judge is responsible for such a decision. In case of decisions made by artificial intelligence, the question arises as to who makes the decision, who should sign it, who will be responsible to the parties for such a decision. For example, when there is some mistakes, and whether such a decision can be legitimate in the eyes of the parties and society, because in society, it is very important to show the independence, the impartiality of judges, the transparency of the courts, and fairness of the procedures. In this context, Tanya Sardins points that in the absence of a clear focus on fairness and related goals, there is a risk that the focus on costs and delays in the consideration of cases will be tempting to automate decision-making more and more, especially in lower courts, is correct. From the point of view of the ODR system, focusing on fast and cheap at the expense of fairness may lead to automated inhuman decisions that cannot be perceived as fair. In addition, in this context, the question arises as to the peculiarities of the language of law, which is obviously very difficult to encode. The law is full of abstract and evaluative concepts that do not have clear parameters. When deciding a case, a judge uses discretionary powers to interpret such concepts, which allow him or her to apply law in accordance with his or her inner conviction and sense of justice, even in cases where the dispute legal relationship is not regulated by a strict and prescribed manner by legal norms. Obviously, artificial intelligence is unlikely to be able to do this. In addition, artificial intelligence will not be able to deviate from the, to change the position, to change the practice, if there is the need to do so in a particular case. And it could not set out a new legal position in judgments to develop the law or create a precedent or resolve a dispute when there have been no similar disputes in courts practice and the machine has no sample for an algorithms for action. So artificial intelligence is unlikely to be able to avoid applying the provisions of the current legislation if these provisions are contrary, for example, to the Constitution of Ukraine or to the practice of European Court on Human Rights, because to do this during the trial, we need to evaluate some cases of European Court on Human Rights and some provisions of national legislation. That's why, all in all, I think that, of course, we could not avoid the usage of artificial intelligence in courts nowadays, and we will go to this. But I think that we can, we should understand that usage artificial intelligence for making decisions and making judgments in courts could not be for any cases. It should be only for that cases where we can see some great level of formality. For example, for example, for order for payments, when we can say, when we can make automatical some conducting some steps, for example, conducting a claim with the particular formulas, and after to make some steps for automated judgments and automated decisions by artificial intelligence. But it could not be used, in my opinion, for every case. Thank you for your attention. I think it's time.
Thank you, dear Tatiana. That was my question, actually. What type of cases is possible to be open for artificial intelligence? Because I believe that we shouldn't open the door wide for AI in courts, especially in complex cases. But then we need to decide which type of cases and what criteria we have for this. And we have, let me say, 8 minutes for questions. So, do we have some? So I can start, yeah? Then I start, and I see that Natalia also have one. I also had one more question to Tatiana. There was, does predictive analytic is not against the legal predictability and maybe against the fair trial? Mm-hmm. Does it something we should recognize as possible to use at all?
Mm-hmm. Thank you for your question, Julia. I would say that if we are talking about Article 6 of European Convention on Human Rights, of course, when in 1950 it was adopted, there was no such attempt to go to see in the future, and there is no points about artificial intelligence. There is only a few decisions which is connected even with digitalization of justice, not artificial intelligence. But in my opinion, when we use predictive analytics, it depends who use predictive analytics. For example, if we use predictive analytics not like we are legal advisors and we use predictive analytics to understand what the decision can be in our situation and whether to analyze whether we have chances to win the case, for example, it is useful tool. But when we are talking about predictive analytics, the usage of predictive analytics tools by judges, we can say that we like doing not justice, but automated everything, and there is no justice in the sense of fair hearing and individual approach to every case. That's why I think that it is not very good from the point of view of the fair trial standards to use predictive analytics from the point of judge. Because judge need to be independent, impartial, and even usage of predictive analytics in the work of day-to-day work of judge can, make questions connected with independence, because it's also influence to you. When, for example, you use these tools, you are a judge and you see, okay, it's like 90% that you need to do this. And in this situation, you can not focus on the details. Yeah. And as a result, you can miss something essentially, some essential points. And in the end, instead of, for example, new legal position or new interpretation development, or, for example, in European Court on Human Rights or in ordinary courts, you will have like some strict perception connected with these tools.
Yeah, thank you. I agree that even could form a habit to rely on this recommendation of algorithms. Thank you, Tatiana. Do we have one more? Yeah?
Yeah, just maybe a short question concerning long answer, as always. So thank you so much for this presentation. It was really very interesting to you know, catalog, to make a catalog of all this possible online and electronic system of dispute resolution, and to find out the place of AI systems in all of this, you know, image of various types of electronic courts. So my question is kind of simple. Do you think Article 6 of the European Convention is applicable to online courts, and in particular to courts which may to some extent apply AI systems, right? And if it is applicable, how can it be applied in the practice of courts?
Natalia, thank you for this very interesting question. So first of all, when we are talking about online courts of the second generation, it's like in most systems, it's like the mandatory courts. So you need to go to this court. But if state says that this court is mandatory court, of course, Article 6 covers everything which actually take place in this court. That's why, of course, all the requirements of Article 6 covers trials in online court. But when we are talking about this conducting trial without oral hearing, in this case, we can say that Article 6, which takes place in online course, Article 6 says, and the European Court on Human Rights says that there is no obligatory and mandatory or oral hearing in even in ordinary courts. And this is the discretion of the state to say whether we need oral hearing even in the first instance. For example, when we are talking about small claims proceedings, or when we are talking about order for payment proceedings, there can be no oral hearing. That's why this transition to the online can be, we can say that there is no violation of Article 6. But of course, there is some concerns. First of all, concerns connected with access to justice, because not even if we are talking about Ukraine, there is no possibility for everybody to apply to this online court if it will be mandatory. So this is the first concern, European Commission for Efficiency of Justice says that if state said that there should be a mandatory online court, they should also prescribe the possibility for people who could not apply to this court to do it like an old-fashioned manner, with paper forms and so on. And for example, in British Columbia, people who have no access to internet, they can do it in paper form if they want to do it. So in this regard, we should be careful.
Okay, thank you. So we should be always non-digitally discriminating. We should not discriminate people by the digital connection or something like that. So this is one of the main points when we are talking about Article 6. Thank you so much. Maybe someone else has a question, or we don't have enough time.
We don't have time for this.
Unfortunately.
So if you have some other questions, please put them in chat so Tetiana can read and answer. I need to introduce now our final presentation and need to introduce Professor Stefaní Laulje Šelou. She is a professor of European law and reform and the head of the School of Law at UCLan Cyprus. She also a director of the Jean Monnet Center of Excellence for the Rule of Law and European Values, and she is a visiting professor at the United Nations Institute for Training and Research. She's very experienced expert of rule of law, human rights and justice, and I'm happy to give the floor for the presentation Challenges to Fundamental Human Rights in the Age of Artificial Intelligence Systems, the Digital Legal Order, the Rule of Law Principles, and European Values. Dear Stephanie, the floor is yours.
Thank you very much, Julia. Hi, everyone. It's good to meet so many experts and listen to a lot of very interesting things. I apologize, I was only able to join the last panel out of the 2 days, but what I heard from the previous presenter was extremely interesting. So thank you for this, and thank you for the invitation, Julia. What I'm planning to do with you is actually present to you the first working paper in the working paper series of the Jean Monnet module, Jean Monnet Center of Excellence for the Rule of Law and European Values, CROLEF, at UCLan Cyprus. And that inaugural working paper is actually written by Julia and myself. So again, it's a real pleasure to be working with Julia. And it has been a very interesting few months upon which we actually came with this very valuable working paper. So what I'd like to do with you today is present some aspects of the working paper, and then perhaps come back to some of the slides of the previous presenter that were quite relevant to what we are discussing here. But before I do that, maybe a few words about the Center of Excellence itself, CROLEF, because CROLEF works quite a lot with your own Center of Excellence. So we are very happy to support our colleagues in Ukraine. Now, in terms of what is CROLEF, as we said, it's a Jean Monnet Center of Excellence. It runs at the University of Central Lancashire, Cyprus campus, since 2022, and it will run until 2025. It has multiple aims, and it has multiple ambitions. 3 objectives are research related or research and impact related, whereas one objective is more on knowledge transfer and teaching and learning. So the main aspect or the main objective of the Center of Excellence is to explore the difficulties with the state of the rule of law and European values in Cyprus, but not only, also in neighboring countries and in Europe. And this is why we work a lot with the Ukrainian colleagues, for example, to try to support also the state of the rule of law and European values in Ukraine. This is achieved via supplementary objectives that are to look at the deterioration or the erosion of rule of law and values across the European Union and Europe more generally, to look at specific threats to rule of law and values, and to look at ways to protect them and enhance them and sustain them, especially in times of crisis, and to look at existing mechanisms available at the EU level, but not only, to try to tackle the rule of law backsliding. So the way we do that is probably more original than the objectives themselves, because the way we do that is via an innovative research and empirical method where we basically collect data ourselves, but we also collect empirical data, not only theoretical and conceptual data. So I will tell you a little bit more about that. And in the making, we actually have, as I said, an objective that is teaching and learning, and we deliver across lots of institutions in Europe, including your own institution, a number of courses. They are online intensive courses, and they relate to some aspects of rule of law and European values. So, for example, of relevance to Ukraine, but not only, the courses we deliver in the field of transitional justice, pros and conflicts, law enforcement in conflict zones. But also we have courses on good neighborliness in Europe, or we have courses on corruption, on terrorist activities, on what is democracy. And so we have different types of courses. All those are available, or most of those are available, via the CROLEF website, and you can actually view them on demand. So you can progress at your own pace. And I think one of them is on transitional justice, is actually translated into Ukrainian. So if you need me to guide you where to find that, I can do that at the end. So this is our cross-cutting priority, that we actually, try to make the widest possible number of people benefit from what we do, and we also exchange, like today, mutually or reciprocal knowledge. Now, in terms of the initial research outputs and outreach activities, which we have at the center, and they are all open access, we have a number of didactic materials that I just mentioned before. So that these are primarily the online intensive courses that I've mentioned. We also have professional trainings available for legal professionals, and we also have training for civil society organizations. We have LLM modules. So these are not on the website because they are UCLan Cyprus LLM modules at the law school. But if you need more information, just let me know, because we open the LLM modules to non-UCLan Cyprus students if they want to. We have a digital library on the rule of law and European values, which you're welcome to consult if you are interested. We have a number of videos, podcasts, and webinars and interviews, which you can view as well in the media section. And when it comes to the research outputs, we have a number of research outputs by colleagues and myself. First of all, we have a research output which I think is very helpful to anyone who would like to understand the concept of the rule of law and European values in a modern setting. So that includes in the digital setting. What do we mean by rule of law? So we have a whole deliverable on that, written by my colleagues Andreas Marcu and Katerina Kaitzaki, online. I can give you the presentation later on if you want to share it with your colleagues. We also have another research output, which is quite important and quite interesting for you to read, and it's rather short. It's called a scoping paper. So it is the scoping paper of the Center of Excellence, of CROLEF. What does this do? It actually sets out the scope of our data collection. So basically it explains, on the basis of data initially collected from our various activities, what we want to focus on, because of course rule of law and European values are very broad concepts. So once you've defined them, then you need to focus on some aspects. And if you read the CROLEF scoping paper, you will actually see a number of pillars and sub-pillars that we have designed based on methodology, which actually set out what we are going to look at and how we're going to look at it. So what we are going to look at, we have a number of areas of interest. One area is the participation of civil society into upholding the rule of law and European values. Another area or pillar is public governance. Another area is the functionality of justice. And the fourth pillar is democratic values. And under those pillars, we have sub-pillars where we have decided that we want, for example, to focus on citizen empowerment, in the context of the rule of law, or we want to focus on anti-corruption measures, or on how to enhance transparency, or how we want to look at access to justice, which is relevant, of course, to the previous presentation, and so on and so forth. So we have a number of pillars and sub-pillars. And then we describe how we are going to do this. And the how is mainly by measuring some indicators, some aspects of those wider areas. So we have a list of indicators, we have a list of measurements. And a lot of the work of CROLEF in the first 1.5 years of its existence was actually to go through all the rule of law indicators, or most of the rule of law indicators available worldwide, to make a comparative analysis of what we thought of those indicators, to what categories they belong. So whether they are UN indicators, for example, EU measurements, or OECD measurements, or whether they are, apologies, whether they are more individual projects. I'm thinking about the World Justice Project, and at what level they are pitched, if it's international, if it's European, if it's national. So we have a rather good understanding of what's going on worldwide in the measurement of rule of law and European values. And we propose not only to measure some aspects of the rule of law, but also to measure some aspects of European values. As I said, we have a working paper series, which we are launching now, thanks to your event as well. And we have a number of other research outputs which are forthcoming, including an edited volume, a yearbook, for which there would be calls for papers, an index, and there will be a final conference. There are recommendations. And as we go, we have a lot of events. So I would suggest, if you're interested, to subscribe to the newsletter so that we can actually write to you when we have events coming up. We also have a number of high-level activities where we meet with decision makers. Now, who we are, other than me, that you have met now, we have a couple of people who are here, researchers and academics at the School of Law, UK and Cyprus, Andreas and Katerina, and we also have a postdoctoral fellow who is working on CROLEF, and her name is Alexandra. Just a few words about the governance of the Center of Excellence, because that may be relevant to those of you who are involved in the governance of your own center. So the way we work is that we have a central foundation with a director, and then we have senior positions held by colleagues, such as the chief research and project manager, but also the senior researcher. We have a postdoc, a number of trainers and officers, and target groups include, of course, the students. But we have two supervisory bodies, one on the left, one on the right. The one on the left on the screen is the stakeholder board that Julia, for example, is part of, and we are happy to welcome more people on the stakeholder board. So the idea is to work together with stakeholding institutions, such as your own institution, and inform you regularly of the progress of CROLEF. Also, we have a scientific advisory board, which you have on the right-hand side of the screen. And that board is responsible for the overview of the quality of the research at CROLEF. They are composed, the board is composed of eminent experts. We have a former foreign minister of Cyprus, the Republic of Cyprus. We have a former president of the Supreme Court of the Republic of Cyprus. We have the only retired judge of the Court of Justice, the Cypriot judge of the Court of Justice of the European Union with us. We have also the former Attorney General of the Republic of Cyprus, the latest one, and a colleague who is a senior visiting fellow at the School of Law in Cyprus, who is based in Denmark. So these are the people who quality assure what we do in terms of research. And last but not least, at the bottom of the governance structure, you can see the CROLEF net. This is all of us into a network so that we can support each other, we can share with each other like we are doing today. If you want more information on CROLEFnet, just let me know. We have a number of materials on the CROLEFnet on the website, actually, and it includes all of us. So the idea is to be inclusive. But enough about the project, and into a number of issues that I want to raise with you. The first one being, what do we mean by the European public legal order, and what do we mean by adding the digital element to the European public legal order? So traditionally, the European public legal order is that order that all of us are familiar with and that keep us busy all the time, which is this order created, this post-Second World War order created at various levels, including the UN level, the Council of Europe level, also the EU level, of course, and quite a few of those other international organizations that are based in Europe. And this European legal order is usually evolving around three pillars. The first pillar is fundamental human rights. The second pillar is rule of law. And the third pillar is democracy or democratic values. And you find a mixture of those three pillars across any of the instruments you're going to look at, whether it is the UN Charter of 1945, whether it is the Council of Europe Statute of 1949, whether it's the ECHR, the EU treaties, particularly the articulation of Articles 2 of European values, 6 and 7 of the EU treaty, and also the EU Charter, and of course the case law of the two main European courts. So, of course, this is the traditional legal order we have had for the past 80 years, more or less, and that is the one that all of us have been trained in and learned about and are applying. So the question is, what do we do with the digital space? What do we do with the digital world? Can the digital version of the legal order fit into that European public legal order? Should it fit into that European public legal order, or should we have a separate set of provisions? So for the moment, it looks like we are trying to blend the two. The previous speaker gave a very interesting account of the various possibilities across the world for the regulation of AI, for example. In Europe, we tend to insert or incorporate or refresh the existing European public legal order through its digital dimension. And the reason is because from maintaining the rule of law will derive the extent to which democracy will be sustained and the freedoms will be upheld under that regime that we have in front of us. So the same question arises, the fundamental question of the nature, scope, and upholding of fundamental human rights, rule of law principles, and democratic values in the digital version of the European public legal order remains. And it is a question that we will try to look at today. Now, just a few words with what we mean by rule of law and European values to start with, so that we can then try to clear the way. I don't intend to do, a theoretical paper or philosophical paper or historical paper. We could obviously talk about the rule of law forever and what it actually means and where it comes from. But what we do at CROLEF is that we blend rule of law principles and concepts with European values. So it's not just about the rule of law. We distinguish the rule of law from other European values. And we see the relationship between the rule of law and democratic values, or other democratic values if you want. And for us, that approach means that we want to look at, of course, formal requirements of the rule of law. Some of them have been mentioned already by this previous speaker. Legal certainty would be one for sure. We also want to look at procedural requirements of the rule of law. There's no doubt about that, such as court proceedings, for example, and court procedures. But we also establish a substantive connection with democratic rule, with the democratic rule, as well as stress the connections between rule of law and values such as democracy, equality, freedom, and non-discrimination. So we actually adopt a rather thick or broad approach to the rule of law. So that means that we are then equipped to look at issues falling within the rule of law scope, such as corruption, transparency, and democratic accountability, or public trust and perceptions of institutions, courts and review of arbitrary power, and free speech, media pluralism, and dissent. And all those are into our pillars and sub-pillars that I described before. Now, let's have a look at how artificial intelligence can impact fundamental human rights, having in mind what I said about rule of law and European values just before. So, first of all, we need to be taking together both European legal orders that are available. So in the broader sense, so we need to look at instruments like the ECHR, but also like the EU Charter, as they constitute together, jointly and severally, the foundations of the European legal order as far as fundamental human rights are concerned. So we do not distinguish between the two. It's not specifically on the EU only. We are looking at Europe broadly as a continent and beyond. So those courts, those European courts across their jurisprudence, they have been interpreting and preserving fundamental human rights in Europe in their own way, but they have actually used similar or complementary mechanisms to uphold those fundamental human rights in Europe, which means that we do have, in the traditional sense, a system of equivalent protection of those rights across those two courts and the two European legal orders they represent. And of course, those rights, those traditional rights, I would say, they are the same ones that are likely to be affected by AI in a modern setting. So it's important that in whatever we do in terms of looking at AI systems in particular and their impact on fundamental human rights, we make sure that we call on the courts, these two European courts, to work together even more closely to reinforce the overall European protection afforded to fundamental human rights in AI cases. So what do we have in terms of AI systems and the regulatory scope so far? I'm sure this has been addressed and developed across the conference, so I'm not going to insist on that. But even if we have no uniform definition of AI and AI systems in the European legal order at large, we have at least several attempts made to provide this idea of an all-encompassing but change-resistant definitions of AIs and AI systems and AI technologies, because it's quite clear, and it has been documented across all levels, that AI systems can have a very serious impact on fundamental human rights in Europe and beyond, because of the way our regulatory framework and human rights are protected in Europe particularly. So if you look at the European Declaration on Digital Rights and Principles for the Digital Decade, I'm not sure whether that was mentioned before, you can see this human-centered or anthropocentric centric interaction vis-a-vis AI systems, but also vis-a-vis digitalization and algorithms. So this is what we are going to look at. Plus, if you look at current EU instruments, and not only EU instruments, also Council of Europe instruments, but the EU instruments need to be much harder, let's say, type of law. If you take the GDPR, if you take the DMA, the Digital Markets Act, or if you take the DSA, Digital Services Act, and the forthcoming AI Act, and some more on digital currencies, for example, and so on, it tends to be always the same approach, which is not a rule-based approach, but it's rather a risk-based approach. So giving this, it gives rise to questions as to how we can protect best fundamental human rights and freedoms in this context, given that we are looking at risk assessments rather than rule protection. So how can AI technologies and systems have a cross-cutting impact on fundamental human rights in Europe? Well, it's cross-cutting because it's very difficult to isolate one particular fundamental human right vis-a-vis AI technologies. So, of course, AI systems can attack individual rights in more or less obvious ways, but they can mostly attack fundamental human rights in cross-cutting ways, meaning when the technology is deployed. So it may start and then the technology expands and more rights are affected, for example, or rights are affected, but at multiple levels in parallel. But more or less, I think we have found with Julia that those are the rights prima facie that would be most affected, and those are traditional fundamental human rights. Some of them are present both in the EU Charter and the ECHR. Some of them are only in the ECHR or in the Charter. Perhaps it's worth mentioning that the EU Charter is a broader instrument than the ECHR when it comes to the definition of what are human rights. So that explains why perhaps the EU Charter is mentioned more times than the ECHR. So out of those rights, we have identified, of course, the respect for private and family life, that makes no doubt, and the protection of personal data, which is specific in the EU, the freedom of expression and information, the freedom of thought, to conscience and religion, the rights of liberty and security, the right to a fair trial, the right to non-discrimination, which was mentioned before, equality of men and women, rights of the child, and the principle of no punishment without law. AI can also impact fundamental human rights at a more fundamental level by eroding the values of those rights. If you look at AI systems in a more functional way or utilitarian way, then there is a possibility that the fundamental nature of the rights may be affected. So in terms of examples that we give in the paper, I've only reported 2 of those here, but there are some more examples in the paper. The first example is the content moderation algorithms, which may affect not only freedom of expression, which seems to be quite obvious, but also, of course, the freedom of thought, conscience, and religion, right to non-discrimination, equality of men and women, and the rights to the child. So if whatever I see or whatever I write is content moderated by AI technology, and whatever I am fed with via social media, for example, is actually predetermined by an algorithm, then obviously all those fundamental human rights that we have mentioned are potentially affected, because this is something that is automated or partly automated for me. But not only that, algorithms themselves, in the way they are designed or used, because of course, as the algorithms are deployed, they are developed and they may be redesigned, that very methodology may be invasive of our privacy, may be selective or biased, may promote polarization of opinions, dilute discussions, as well as generally contribute to the formation of a certain image of the world among users of digital content. And this is, of course, at the basis of what we call fake news. So when describing the impact that AI systems can have on fundamental human rights, like we just did now, it is not always easy to ascertain the specific impact on specific rights affected by the technologies. So the question arises as to how to best prepare them and protect them as a group of rights, but also individually. The other example that I wanted to share with you, which is an obvious example again, is the ability of AI systems to track users both in the public and the private sphere of life. And we all know that this is very outstanding. I'm sure that you have all experienced being served on your mobile phone with or suggested feeds on social media whereby you've never searched for those things, but you mention them orally while having conversation and not having your mobile phone very far away. And this is picked up via Siri or Alexa or various other AI assistance tools. So this is particularly because it's not necessary to use technological artifacts directly to be the object of certain tracking actions. And that is also the case when it comes to monitoring and tracking our every move, but not only, could be monitoring, tracking our health, for example, but also monitoring and tracking our preferences, consumer behaviors, or monitoring, tracking where we go and what we like. So whatever bits of information that is put in the digital space by others about us in the form of photos on the other side of the world, for example, but it could be something more serious as well, related to conflicts and war zones, can make it easier for non-users to track them because AI can search, process, combine, compare, analyze those bits of information. And AI can also keep track of what people have been interested in and weave it into their online searches intrusively or more subtly. Algorithms can even establish a match on a photo with a person who did not take or post this photo on the network and may even not have known that this was taken, determining the location of this person at the specific time, which can be very problematic. So AI technologies used in public spaces, in particular by public authorities, can go very far. We have all experienced this in airports, for example, and in CCTV and other surveillance tools. And the real question is whether this is acceptable in a democratic society, upholding rule of law principles and European values, as well as fundamental human rights. Talking about which, we with Julia collected and suggested a number of new fundamental rights. They are not that new, probably, in the sense that they exist already in their traditional settings, but perhaps it's time to renew them, refresh them, upgrade them, expand them. So we have different ideas on that aspect. So apart from that significant change of scope of those rights, we may also think about introducing new rights, which means that we could think about changing the status of specific existing rights from rights that apply to certain categories of persons, such as user rights and data subject rights, to fundamental human rights that are of utmost importance to all human beings in the digital world. So here I have briefly put together a comparative table. On the left-hand side, you've got a couple of rights that we are either suggesting or we wrote about elsewhere, or we confirmed with existing literature. And on the right, you have a table of existing relevant rights and how we suggest to expand or extend those rights. So let's start with the left-hand side of those new rights. And I specify that these are not absolute rights, of course. So there is a red line for all those rights, and there are limitations for all those rights, of course. Particularly the right not to be subjected to automatic decision-making and to automatic processing in the broader sense. Why is that? Because human withdrawal from semi or fully automated decision-making is one of the red lines of the European digital public legal order. We cannot withdraw fully human interaction in those automated systems of decision-making. So the new dimension or broader sense of the right must include the requirement to have a human-centered decision-making process controlling the AI decision and being ultimately responsible for it. Of course, this right exists already in Article 22 of the GDPR, which provides for the automated individual decision-making, including profiling rights. But that is only in case of automation. And this is limited to seriously impactful events. What we propose is a broader human right, fundamental human right, a principle of not to automatic decision-making and automatic processing without any human-centered overview and control, and without being informed of the automation process. The second one is the right to influence one's digital footprint. All of us have a footprint, more or less visible and more or less intentionally. Many of us have a footprint rather by default or de facto, unintentionally. So individuals should have the right to participate in their digital lives in such a way that information is reviewed in accordance with time past and its significance to the individual and not only to society. So of course, here there must be limitations, particularly when it comes to hate speech, hate crime, and of course, criminal activities and convictions, or even suspicion of illicit activities, but we developed that in the paper. So we are aware, of course, all of us, of Article 17 of the GDPR with the right not to be forgotten or the right to erasure. But again, this is very difficult to put in place in practice, first of all. Secondly, it's limited to the protection of personal data. So we are suggesting to basically have a more elevated, more fundamental right to influence our own digital footprint that actually should belong to us. And the third one that we propose, which I have reported here, is the right not to be measured, analyzed, or coached. Both states and companies are increasingly resorting to mass surveillance and collecting the smallest detailed information about people. So such a right could include obligations not to resort to mass surveillance, at least in some places that should remain private, and not to resort to 24/7 surveillance when another alternative is possible. So we also question the way European courts have so far looked at the legality of mass surveillance measures, whether the right questions have been asked or answered. And of course, here, you know, it's important to go back to basic principles of rule of law, good governance, such as proportionality, necessity, and subsidiarity, because these are the principles that would actually help us understanding whether a surveillance action or an intelligence action by the state in particular is justified. Now, this also applies to the private sector, given that, of course, with the GAFA surveillance and tracking and intelligence is also happening via our platforms and social media and other big tech companies. So this is also important for them, but in such a case, they should also be subject to the same type of proportionality testing, which of course is not something that is on the table at the moment. They are usually caught, as we explained in the paper, for reasons that are usually more related to competition than to anything else. So the working paper, and this is my conclusion, calls on all proposed AI regulatory standards to be clear and strict in the sense that they do not allow putting human rights at risk and of driving people and societies away from the fundamental benefits of digitalization at a higher cost vis-à-vis the benefits of technological developments and innovation. Achievements in the development of AI should not be evaluated from the standpoint that is a race between democratic societies and future technologies, because ultimately we want to have both. Democratic societies based on the rule of law and fundamental human rights, in which everyone benefits equally from technologies. And this goes back to the conclusion that was made in the previous presentation. So I thank you very much for your time and for listening to me. I'm happy to take any questions and discuss the two presentations as one. Thank you.
Thank you, dear Stefani, for this all-encompassing and structured presentation of our funding. I'm honestly so proud of us and hope we can convince other experts about AI impact and new human rights. I feel that I can't to ask questions because that's something we had developed together, but we have time for one or two even short questions. Do we have some in chat? No, there was some gratefulness from people who need to leave us. Natalia, do we have some?
So I think we don't have currently questions from our guests, but maybe we can start with the questions and then our guests will also join the company. So I have a short question. I recently had an opportunity to look through some projects initiated at Oxford University, I think, and there was an interesting project concerning the research and analysis of the right to mental integrity in digital world. So this was really, I found it really interesting. I never thought about it, but it was it concerned the issues like, for example, in modern world, we usually stick to our gadgets, right? And in particular, we like reading news in the line. You know, we just scroll and scroll and scroll, and this endless scrolling is very, I should say, dangerous for our kind of mental integrity, because all these lines of news, they are endless, and usually it comes down to, you know, to just doom scrolling. When you just focus on something bad, you're looking for something bad or something like that. And this is this is only one example of possible you know, concerns about the right to our mental integrity. Did you analyze this right in your research within CROLEF? And do you think it is really one of the possible options, you know, to say about this new generation of digital rights, the right to mental integrity?
Thank you, Natalia. That's very interesting. Before CROLEF, I mentioned before Jean Monnet module instead of Jean Monnet Center. That's because I was leading a Jean Monnet module that was looking at populism. And we worked quite a lot on digital populism and the way, obviously, populist ideas can spread via digital means. Scrolling is a good example of that. In addition to that, I was also the legal expert in the Horizon 2020 project, which is now finished, but it was on AI and human rights. And actually, all the resources are still available online, so I can give you the details if you want. And in there, we worked a lot on what I call the right to meaningful intervention. So it's a bit like what you're saying. It is mostly relevant to the rights, It's mostly relevant to robots' interventions and the way robots can replace, to a certain extent, human actions, particularly when it comes to healthcare. So I worked a lot on that. And actually, I said rights of robots because I even ended up with the team working on whether robots should indeed have rights, if you compare to the rights of corporations, for example, or if you compare to the rights of animals. So these are very interesting discussions. So I think what you're suggesting is encapsulated in this idea of the right to meaningful intervention. If you are going to intervene in what I do as a human being, that must be for a purpose, purposeful and meaningful. It must have a sense. So in your example, obviously, there is no life-threatening situation, hopefully, but when it comes to healthcare, there are life-threatening situations there. So that's a very interesting field and very interesting right to think about. In a number of public consultations by the European Commission on the way to the AI Act, I participated and proposed a number of rights. So perhaps if you read the working paper, I gave the link, but I can share it again. Julia can share it again. The public consultations are mentioned in the working paper, and you can actually read them because they're online. The EU publishes everything. And you can see what sort of other rights, because there are other rights that we actually looked into.
Okay, thank you so much. Yeah, what I wanted to say by this by this question, right, was that sometimes when using digital technologies in our everyday lives, we lose the control on what is going on in our brain, you know, and this is just one of the possible manifestations of this problem. Again, when we scroll some I don't know, the line in the Instagram or on Facebook, we find ourselves in a bubble which we created by ourselves and by the targeted advertisement, and it also raises concerns about whether we control or we don't control our mind anymore. So thank you so much. Thank you. So do we have any other questions from our guests?
I'll take half a minute to have a short comment because I thought about this right previously, and I know that Professor Anna Saralind, who was here today in the morning slot, she's also interested in integrity and AI impact. And yeah, there is a right to integrity of the person, yeah, in EU Charter, but the previous focus was mostly on the physical and mental integrity regarding to medicine and biology. But yeah, I believe that it's a question we need to raise, this integrity as something which could be affected seriously by AI. Unfortunately, we go beyond our time, and we need to stop here. Maybe we will promise the next discussion in some months, and also we will have one more the next year. But for now, I want to thank again to Stefani and to thank all our other speakers and our participants. And we will be happy to get some feedbacks from you by mail, for instance. So yes, we need to close this discussion at least for this day.
Thank you so much. Thanks to
Thank
all
you,
of you.
everyone. Stay safe. Bye.
Thank you.
Bye.
Thank you. So, yeah, thank you so much to every participant. We need to go, yes, and see you next time at our future forums.